There are many extremely unhappy second spouses who lost hundreds of thousands of dollars or more. Hi, Jeff Marsacci, the Plain English Attorney, and welcome to the video. Today we are going to talk about 5 estate concepts that people get wrong. Now, please stick around to the end because we're going to run through what a good estate plan looks like, and we're also going to provide you with some free materials to get started on your own estate planning journey. Now, the internet can be a tremendous help with research. However, there are a lot of myths, misconceptions, and outright falsehoods out there, especially when it comes to estate planning. We are also living in an age, in a time, when people can simply turn off the facts that don't go along with what they want to hear. So it means if they don't have to take action and be lazy, well, okay, I'll just turn the channel and get the answer I want. We don't have time to list all of these things that people get wrong, but here are the top 5 things we have curated to help you get started. And the first concept, look, wills don't control everything. Many people assume that a last will and testament is the end-all be-all, and it's the preeminent document overseeing everything, and that what the will says has the force of law. Unfortunately, that is not true. And many people mistakenly think that a will is a complete plan in and of itself. It's not. If a person does a will, gets remarried, then executes a new will, naming their new spouse as a beneficiary, this does not automatically change the beneficiaries on life insurance policies. This does not automatically change the beneficiaries on retirement accounts or beneficiary designations on bank and stock accounts. There are many extremely unhappy second spouses who lost hundreds of thousands of dollars or more in life insurance and accounts to their spouse's ex because the policy and the accounts were never changed. A will can be an extremely important part of an estate plan, but by itself, it's not the whole plan. It just doesn't work like that. Now, the second concept that people get wrong all the time, wills do not avoid probate. Many people mistakenly believe that a last will and testament just acts like an all-access pass to transfer assets after death, and their estate avoids probate court. No.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
They assume that their executor can simply take the will to the bank, start withdrawing money, taking control of assets, and then turn it over to the beneficiaries. This is definitely untrue. A last will and testament instructs the probate court how to distribute assets after the probate court process and the procedures are followed and all the paperwork submitted and everything's approved. And then it goes to the beneficiaries. Usually the first hint that this is not a simple process is when an executor calls a law firm asking them, hey, can you type up this letters testamentary that the bank's been asking for? That's when they get the bad news that they essentially have to initiate the equivalent of a lawsuit in probate court to get those papers that the bank offhandedly said, oh, we need these letters testamentary. They make it sound simple, and it isn't. It's starting the whole process. Now, many people consider probate an expensive, time-consuming, frustrating process that gets in the way of a family inheritance rather than helping the family with the plan. Unfortunately, this is true of many estates, and people try to avoid probate for their loved ones, including through the use of a revocable living trust. Now, we're going to talk more about that later. But for more information on revocable living trusts, you can always check out my book, Estate Planning Basics, that's available on Amazon.com. However, we do have it linked at estateplanningBasicsBook.com, just to make it easy for you. Now, the third concept. Look, lawyers make a lot of money when people do it themselves. You ever wonder why there's no big outcry from attorneys about, say, LegalZoom or some other online computer generated legal document companies? You go in, you type in a couple of things, it gives you the document. Well, look, it's because it's easy for non attorneys to mess these things up. And then the attorneys end up having to go to court and litigating what the person actually meant. And suddenly, in a court of law, now these documents that were supposed to avoid problems and list your plan and make everything nice and easy, it becomes a huge financial boon for those estate litigation attorneys. Now, one attorney who regularly contests wills for his clients, he mentioned that they always know they've got a winning case when someone walks in and says, here's a copy of the will, and it's a LegalZoom or other do-it-yourself document, and someone wants to contest it. Look, our firm has reviewed hundreds of estate plans, and without fail, the do-it-yourself documents never 100% state what the person intended. And probably about a third of the time, or even more, they're not even signed correctly. This makes the plan completely worthless. Now, like everything in life, you're going to get what you pay for. And planning right can save hundreds of thousands of dollars or more in legal fees, months of delays, and an unfathomable amount of aggravation for the family if you do it right up front. Right. Fourth concept, beneficiaries inherit at 18. Now, people are often shocked to find their estate plan does not line up with their accounts and insurance. Even if a person had the correct beneficiaries listed on their accounts, listed on their life insurance, listed in these beneficiary designations, they're puzzled that the age restrictions that placed in their wills means absolutely nothing. Most people believe 25, 30, or even 40 are appropriate ages for inheritance, and those limits are in their will or their trust document. Well, insurance conveys large sums of money quickly while avoiding probate. But if a child is a direct beneficiary on that life insurance policy, the insurance company is legally obligated to give the funds over to that child if they are 18. Now, there may be some exceptions in policies for age 21, but that's still too young. Look, that's not right. It's not what was intended, clearly, but that's how it is. Insurance, bank accounts, stock accounts are based on the contracts, and the contracts often just follow state law, and it states that a beneficiary receives the insurance or the money or the stock at 18, then it doesn't matter what was in the will or the trust. And again, it's because they were the direct beneficiary. Now, the fifth concept, look, many attorneys know a lot less than they think about estate planning. More and more attorneys focus on certain areas just like doctors, and estate planning can't be adequately addressed by, quote, general practitioners, by the divorce attorney that, oh, I suppose I can do a will or a trust. But look, unlike medicine, there's a good chance that a mistake will not be found until the person is deceased or they're incapacitated, and by then it's just too late to do anything about it. When checking out an estate planning attorney, we've got 3 summarized things that really make it the way to look for an attorney. Look for the number of years that the attorney has specifically been working with estate planning. 2, make sure it's a large percentage of the practice is focused on estate planning. I'd say at least 50% or more. And 3, this is the big thing to check. How much does their firm make on probate versus planning upfront? Now, this last one is mainly if you want to make sure that you're avoiding the probate court process as much as possible. Attorneys that grossly outnumber revenue on the administration end of the probate process versus the planning end, well, look, they tend to recommend estate plans that put more money into their own pockets. And they may even say, look, probate's no big deal. Well, it's no big deal for them, but they make a lot of money for it. this is not going to save on the probate costs for the family. All right, so what are the documents that are out there? Because look, there are many minefields and pitfalls to avoid in an effective estate plan. Our firm is experienced in helping people avoid probate, and this is why a lot of our clients actually come to us to help them reach their planning goals. Now, there are different techniques, documents, and methods of putting together a solid life and estate plan that's going to fit your particular goals. But here are the big documents that we typically see. Number one is a revocable living trust. This forms the base of the estate plan, which lists everything, and what's in the trust avoids probate. Second, a durable general power of attorney that empowers someone to handle financial things outside of the trust if anything happens to you. A healthcare power of attorney, so who's making healthcare decisions. A nomination of conservator form. This is for you. What if you become incapacitated and someone feels they need to go and get a guardian assigned? This document is in there. Now, if you're doing a revocable living trust and you have a durable general power of attorney, you have a healthcare power of attorney, you probably shouldn't need it, but look, this is a good backup thing. You should also have a living will if that's what you want. Most of my clients don't want to leave the burden of making an end-of-life decision on their loved ones, so they put together a living will. Now, there's also a last will and testament, but it's called a pour-over will. So this pour-over will makes sure that if anything does end up in probate, which shouldn't be a lot if you're funding your trust the right way, then it goes over to the trust, and you don't have to list the names, ages, and addresses of all the actual beneficiaries in the probate paperwork. You just list the name and address of the trustee, and that saves people from getting on the marketing lists. Now, bonus document, it's an appointment of guardian. So this is if you have any minor children or you're the guardian of someone who is an adult, but they're disabled and you're the guardian. Now, all of these documents work together to cover most of the main goals, and they form the solid foundation of a good life and estate plan. Now, while there's a lot of misinformation on life and estate planning, we can help you reach those legal planning goals and help protect your family during a crisis, something that's already going to be a difficult time. So for more information, this is what I'm talking about for free stuff on a complete estate plan. Check out our free program at freetrustcourse.com. Again, that's freetrustcourse.com. Now, if you've made it this far, please like the video, subscribe, and share it with people that you care about who might get some good value and benefit from it. And look, if you would like to support the channel and our work in getting this information out there, then please consider becoming a member or hitting that thanks button and giving us just a little bit of help. It really does make a huge difference in helping us get this content out there. Now, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.